Hi, this is Mark Sokolow. Today we're going to talk about pipeline safety. A little bit we're going to go into the Texas state law and regulations on pipeline safety, and then we're going to examine the City of Port Arthur's regulations on pipelines. They have over 100 pipelines that crisscross that city. It's a major industrial city of Texas, and not just of Texas, the United States. You have huge refineries there, Motiva, huge chemical plants, BASF, which has one of the largest olefins units in the world, and of course, you have the Intercoastal Canal with barges, but what really feeds the pipeline, the refineries, is the pipelines. So today we're going to look at the Railroad Commission, some of the regulations in the Administrative Code. We're going to look at some of the regulations or ordinances of the City of Port Arthur, and then we're going to look at a pipeline permit. Now, this program or this video is designed for my business law students, and I hope you enjoy it. Thank you. The Texas legislature has passed several laws as it pertains to pipeline safety. Specifically, Section 121.201 of the Utility Code delineates that the Texas Railroad Commission may enact rules prescribing safety standards for pipelines. And in fact, they have done so. They also specifically indicate under Section 121.202 that a municipality, a city, may not adopt or enforce an ordinance that establishes a safety standard or practice applicable to a facility, for example, a pipeline, that is regulated under this subchapter, another state law, or a federal law. Now, it does preserve the ability of a city to adopt an ordinance that establishes conditions for mapping, inventorying, locating, or relocating pipelines over, under, or across a public street or alley or private residential areas in the boundaries of the city, or establish conditions for mapping or taking inventory. So we have a situation where you have state laws and a state agency, in this case the Texas Railroad Commission, adopting regulations for safety, and of course you're going to have city ordinances that pertain to pipelines as well. Now what we're looking at here is Title 16 of the Texas Administrative Code. The Texas Railroad Commission has adopted pipeline safety regulations under Title 16, and we're going to look at a few of these. Under Title 16 of the Texas Administrative Code, it indicates that companies should have risk-based plans that identify the pipelines, provide inspection data, provide pressure test data, that give information as to construction records, as to the age of the pipe and the operating history, the pipeline specifications, and the type of pressure test. Periodically, they're supposed to be doing assessments of the pipeline and provide that information to the Railroad Commission. Now, our next step, what we're going to do is be looking at certain city regulations, specifically the regulations that the City of Port Arthur has adopted. The City of Port Arthur has literally hundreds of pipelines that crisscross the city. The City of Port Arthur has adopted, of course, its Code of Ordinances, and under Chapter 66 it has a whole section on pipelines. where if a pipeline wants to go through the city, they have to get a permit, and they really have major permits and which require council approval, and then they have other types of permits which just can be administratively approved. But they provide liability protection, minimum standards and specifications. As you understand, for pipelines that go through the city, of course they're going to be crossing city streets, so the city wants protection as pertains so that there wouldn't be leaks, and they want certain basic protections, and they do require certain fees to be paid. Let's take a look at minimum standards. All new pipelines, relocated pipelines should be designed and constructed in accordance with the latest approved minimum standards established by the United States Department of Transportation or the State Railroad Commission. So they're doing their best to coordinate the specifications of the city to the state and federal laws. When they do provide information to the city for a pipeline, they need to give drawings, description of the materials transported, their pressures, things of that sort. They're supposed to provide markers. They're supposed to provide information as to when there may be a spill, discharge, or release, who they're going to contact. We expect that leaks to be reported. Here's the permit fees. It's a very modest amount. This is the section 66-53 that deals with major permit applications for new pipelines not along a preferred route, or a new pipeline along a non-preferred route. That's basically the major pipelines. What you see is that you end up getting routing information, the depth of the pipeline, information as type of insurance. They do need to provide liability insurance, bonds. Here they're required to at least have a $15,000 bond as well as a $3 million insurance policy. Again, minimum standards. Now in a few minutes what we're going to do is actually look at a permit application. Now what's very important is that being that cities provide emergency response, both fire and police, these regulations are absolutely essential for cities is to know where the pipelines are being located in their city and how deep they're going to be, what type of protections they're going to have in terms of casing, and especially if they're going to go underneath a street. Hi, this is Mark Sokolow again. This is an example of a real pipeline permit. You have a case where a company, in this case TE Products Pipeline, wants to install, in this case, 8 pipelines to the city, and they want to go down West Port Arthur Road, just south of the BAS plant. They made an application to the city to install the 8 pipelines, and it's going to service the Motiva refinery, which is actually very important to the city. Of course, if you know anything about the city of Port Arthur, it's an industrial city, and they really need these supply pipelines to service the refineries, which provide a lot of economic development, a lot of employment for the citizens of Port Arthur. They have an advisory committee, a pipeline advisory committee, which is made up of volunteers, and I think the city engineer that looks at these pipelines and provide their comments. In this case, they recommended approval. They provide a public hearing for citizens' input, so they try to get everybody involved. The Director of Public Works and Director of Planning has reviewed the application, and they recommend that it be granted. This is the second page of the resolution. These pipelines are actually going to go down an existing pipeline corridor. and it's authorizing the mayor to execute on behalf of the city the pipeline permits, to approve the permits. And it was approved by the City Council on April 22nd, 2008. And you can see the full copy of the approval by going to the City of Port Arthur website and looking up Resolution 08-155. It was approved by the City Council, and of course it was also approved by the City Attorney, which in that case was myself, Mark Sokolow, City Manager, Director of Public Works, which is Mr. Como, and Mr. Watson, the Director of Planning. Here's a letter from March 20, 2008, where it says the advisory committee unanimously recommended the approval of the construction of the pipelines. This is a copy of the actual permit that's going to be issued to the pipeline company. It cites the Port Arthur regulations, which is Chapter 66. They're going to be propane pipelines. They're granting them of course, they're giving them a permit. Of course, the pipeline company is getting the permit, but they're going to have to get right-of-ways and easements from the various property owners directly from them. If they're going to be installing the pipelines with any public streets or easements, they need to do so based on the instructions of the city engineer. This is the section that's important to pipeline companies: is what conditions are cities putting on them to actually install the pipelines. Some of which is pretty standard that we expect them to meet. That's Department of Transportation Class 4 design requirements, which they would do anyway. They can't lay a pipeline longitudinally under existing or proposed pavement. In other words, they just need to go across it. They expect that when they do go across the street, they need to be done by the bore method. In other words, they're just going to bore underneath the street. They need to have, all pipelines need to be cased for a distance not less than 1 foot beyond the right-of-way line of the street. They need to have cathodic protection, and they need to have a minimum depth of 4 feet below the ultimate flow lines of any existing ditches. Now this is what's really important. Of course, you're thinking about pipelines going through cities, but what happens is you really have to coordinate the pipelines with the city infrastructure. In other words, the cities have roads, they have ditches, and of course you have electric utility lines and other electric lines and gas lines and things of that sort. All this needs to be coordinated. And in this case, what they're trying to do is says, yes, you can go underneath city streets, but the pipelines need to be of a certain depth, and they need to have certain casings, and this is just what we expect. And this is pretty standard, actually. We're also indicate they need to have the minimum standards established by the American National Standards Institute, United States Department of Transportation, other pipeline regulatory agencies. If there's different standards, we expect them to go by the most stringent. They're supposed to notify the city engineer of any leak. And this is where you get into the preemption. The provisions of this permit shall be subject to any federal and state legislation, rules, or regulations enacted or adopted, or which shall be hereinafter enacted or adopted to the extent that such laws and regs shall preempt or supersede the authority of the city. So basically what's happening is we recognize that these pipeline companies are going to have to abide by state and federal regulations. And if there's state and federal regulations that specifically deal with this, those laws would supersede these. And it also indicates here, this is really important, if later there needs to be street improvements, then the permittee, the pipeline company, has to lower the pipeline or adjust it at their expense. This is actually pretty major. So what happens is what you're seeing here, pipeline companies come in, you have advisory committees, you have public hearings, we try to get them into public corridors or pipeline corridors. You want to get them as deep enough so they won't affect existing streets or drainage. You want to see that they're cased underneath the streets so they're not affecting the streets. You want a situation so that the city needs to adjust the street or rearrange the location of it. The pipeline company has to move the pipeline at their expense. And of course you have certain aspects of safety, that there's a leak, they need to notify the city engineer. Because the fact of the matter is, if there are leaks, who's going to be affected most by it? It's going to be the residents of the city. And the people that are actually going to respond to it in the first instance is not going to be the Texas Railroad Commission, is not going to be the federal government. It's actually going to be the city's fire department and police department. There's a practical side to all this.